Hi, this is David Bliven, Bronx and Westchester divorce attorney with another episode of Lessons from the Divorce Wars. So, the question has arisen relatively recently, what happens if a party is awarded counsel fees? How do they manage that vis-a-vis their own attorney? So, just to preface, in New York State there's a presumption that the less moneyed spouse can get their counsel fees reimbursed by the more moneyed spouse, either by settlement or by court order upon, obviously, a proper application. So then the question is, okay, what happens if that party is awarded, let's say $10,000, $20,000, $30,000 or more in the course of the case, either by settlement or court order? Well, part of that is working that out with your own attorney. So that requires communication. Let's say if the settlement or the award directs the more moneyed spouse to pay that counsel fee award directly to the party as opposed to the attorney, but the attorney is owed money, the client still has to pay their attorney, generally speaking, unless you work out some other kind of arrangement. So it's not as though that party can then just say, look, I'll get that $10 or $20 or $30,000 or more and then just stuff it into my wallet and, no offense, ignore my lawyer. Well, the lawyer's going to have several different remedies. If your case is still pending, that lawyer can go to you and say, look, you either have to pay my bill with that counsel fee award or I'm getting off the case. I'm getting relieved as your counsel. If, let's say, the award happens at the end of the case, either, again, by settlement or court order, and the attorney is owed money at the end of the case, the attorney can go back to court and say, hey, the award was paid directly to my former client. My former client got the money and stuffed it into their wallet and is refusing to pay my final bill. That attorney can move for what's called a charging lien. A charging lien means they now have a lien against any other monetary award that party is going to get. So either further counsel fees or a property or some other asset distribution, usually not against child support, however, but they can have a lien set up. They can also move for a money judgment that would accrue interest at 9%, which is a really high interest rate. It would not make financial sense for a typical party to ignore that and dare their attorney to get an award of interest. Instead, the attorney and the client should really try as best as possible to rectify that issue to ensure the payment of counsel fees satisfies the attorney's bill, because that's what it's intended for. That's why it's called an award of counsel fees. It's not a gravy train, no offense to the client. That's what asset distribution is. That's what child support is. That's what maintenance is, et cetera, et cetera. If a client or former client is unsure about that, have that communication with the attorney. If there's any kind of dispute between the attorney, they can move for fee arbitration, they can get a second opinion from another attorney. There's many other remedies that client or former client has. The other thing that the attorney can do, depending on the wording of their retainer agreement, they can go back to court and say, look, I wouldn't have had to file this application with you, Your Honor, but for my client or former client's ignorance of my bill. So now I want, Judge, you to tack on the fees that I'm going to charge for filing the motion, as well as appearing on that motion, stick it on to the overall balance that I owe. That could be thousands of dollars added in, depending on the hourly rate of the attorney. Not a wise thing. So try and work that out with your attorney, rather than dare an attorney to kind of say, well, gee, I'm not sure my attorney really knows what to do or their right to the courthouse. Probably not a wise dare on one's part. So if you're looking for similar answers to questions like these, check out my blog. You'll find it at blivenlaw.net/blog. See you next time.